Okay, we're going to get started. We have a special treat today. First of all, I apologize for our preeminent Professor David Wilkins, who could not be here today. He is actually lecturing and speaking at Georgetown Law School. So on his behalf, I am delighted to welcome Erika George. Lest we only be known for big corporate law, today you're in for a different kind of talk, which is great. And Professor George has a JD from our own alma mater here, Harvard Law School. She has a Master's of Arts from the University of Chicago and a Bachelor's of Arts from the University of Chicago. Professor George, prior to joining University of Utah S.J. Quinney College of Law, Professor George served as a law clerk for Judge William T. Hart on the United States District Court for the Northern District of Illinois. As a litigation associate for the law firms of Jenner and Block in Chicago, Cordat Brothers, LLP in New York City, and as a fellow and later consultant to Human Rights Watch. In connection with her work with Human Rights Watch, Professor George conducted investigations in South Africa on women's rights, children's rights, violence and the right to education, and abuses related to HIV/AIDS epidemic. She wrote a book, Length Reports, Scarred at School, Sexual Violence Against Girls in South African Schools, which received widespread media coverage in South Africa and internationally. He currently serves as special counsel to the Women's Rights Division of the Human Rights Watch. Professor George's scholarship has appeared in the California Law Review, the Michigan Journal of International Law, the New York University Journal of International Law and Policy, and the annual proceedings of the American Society of International Law. Her research interests include globalization, an indivisible, independent, and interrelated nature of civil liberties and socioeconomic rights, cultural pluralism, the rights of universalism, gender violence, gender equality, justice, and peace promotion to post-conflict interests. Wow. Her current research explores the responsibility of transactional corporations to respect international human rights in various efforts to hold business enterprises accountable for alleged abuses. She has presented her research internationally, addressing audiences in Europe, Africa, and South America. It is really a delight to welcome you home to address us.
Thank you so much. I'd like to thank the Center on the Legal Profession for having me and for my hosts. It's been a pleasure to meet you both, and Nathan, thank you for everything you've done to arrange. And for you for attending. I know from that bio it sounds a bit like I have academic ADD, but it is the case that I do believe that international human rights are interrelated and interconnected. So I hope by the end of this I will persuade you that it is all interconnected and that businesses do need to incorporate human rights into their operations. So I'm going to talk to you today about that. So I'm going to start with a frequently repeated refrain that you've probably heard before. These are the comments of Nobel laureate in economics, Milton Friedman. I'm also at University of Chicago. And when presented with the question, what is the social responsibility of business, this was his response. And it remains the dominant paradigm. The responsibility of business is to make profits within the boundaries of the law. What I want to challenge you to do is think about how this paradigm might be disrupted. There are three stories. One is the story of Xin Tao. He was a journalist in China, and he didn't report on the 2008 Olympics because he was imprisoned. He was imprisoned because his information was turned over to the Chinese state security forces by Yahoo. He'd used the Yahoo account that he had to send an email to a pro-democracy organization in the United States, and for that act of state subterfuge, he was imprisoned for 10 years. Owen Saro-Wiwa never will vote in a Nigerian election. He was executed by the military dictatorship in power, protecting Shell's oil interests in the region that he called home, the Niger Delta Ogoni region. He'd been an environmental activist, alleging that damages from the pipeline were harming his community. The security brought in by the state to protect the pipeline didn't protect his community and resulted in his death. That was a lawsuit that found its way into the United States, ultimately settled out of court. Again, what was the responsibility of Shell in that context? Chiquita Banana, Pablo Perez, 50. Pablo is one of many. He's one of the many plaintiffs who brought suit in the United States. He lost his life after labor organizing and being killed by the security protection forces brought in by Chiquita Banana that were paramilitary forces that are on terrorism watch lists in the United States. The company explained that they had no other alternative than to hire security that was available to them, much like Shell. So when pressed, what was unique about these cases is it's not that human rights activists looked to Colombia or Nigeria or China alone. They looked at the interconnection of the corporate actor involved in this, the ways in which they caused, contributed, or were connected in some way to these violations. The kind of response that typically was given after the aftermath of these situations echoes what Jerry Yang, former CEO of Yahoo, explained. Look, we're within the bounds of the law in the context in which we're operating. So what is the choice? What is the responsible corporation to do? Do we have to question whether operating within the bounds of laws that are inconsistent with international human rights norms are sufficient for shielding us, if not from liability if we're a corporate actor, to looking to what our obligations actually are? How do these problems occur? Well, in our field, we term it a governance gap. The notion is that home states are unwilling or unable or reluctant to reach across borders and regulate inside another country. So the home country in which a corporation is incorporated isn't really wanting to engage in these issues. And a host country where you may be investing or operating as a transnational corporation may not have the capacity, the will, or the ability to regulate in ways that protect human rights. So the work that I do currently is looking at how to close this regulatory gap. Where public state actors are not sufficient, is there a way in which private ordering can help resolve some of these conflicts? And I submit that there is. So I'm going to talk to you today about the role of lawyers in contributing to closing the governance gap. I'll do this in 3 parts. I'll first give you a bit of context that goes into why it is we find ourselves in the situation that we do, where there's a regulatory governance gap that allows corporations to be at risk of contributing to human rights violations. And I'll then tell 3 more stories about conflicts between businesses, corporate actors, and communities, how the legal system was involved in those different contexts, and the role that lawyers played in resolving them. And then finally, I'm going to give an account of how lawyers can help contribute to change, and the ways in which business actors are being responsive and are incorporating rights in ways that will require us to assist. So context. I would submit that corporate law, its dominant paradigm, contributes to some of this governance gap. And that's because we understand the primary purpose of the corporation to be centered on profit maximization. So the interests of business is to maximize profit. Arguably, there's more room for education about human rights, but how would you bring that in? The purpose of the corporation is to produce goods and services, and in that way, we produce good for society. Writing a generation ago, also a Harvard Law professor, Adolph Burl, cautioned us about the dominant paradigm, particularly as industry was beginning to grow. He's writing prior to the New Deal society, and he made this observation after studying with a Harvard Business School professor, Gardner Means, that we could anticipate the way that corporate structure, at least in the legal architecture, is going. We will wind up with really powerful private actors that could rival states. How to use that power, he suggested, could be spread beyond just the shareholder, because there's a separation between ownerships and control. If owners are not actively engaged, societal interests should come into play. Generations later, Leon Sullivan, who was the first African-American member of a board of a major corporation for GM, also started to push this notion of corporate social responsibility and the use of power in engaging corporations in South Africa. Companies have been operating in South Africa during the apartheid regime. It was his position that if you were a powerful multinational corporate actor, you might have influence on the sovereign in which you're operating. So he called on companies to resist racist apartheid laws and practice equity in the workplaces that they did control, a clear challenge to state authority. And what this did was help move business away from the focused myopia on just a bottom line. He introduced the Sullivan principles, and rather than focusing solely on what the profit impacts are, he started to look towards other stakeholders and encourage leaders to go beyond that. Companies now are transnational as a matter of routine. They're also incredibly complex. So human rights activists are concerned that this complexity makes it more difficult to detect where you can intervene to alter a human rights impact or outcome. And the increasing complexity is only becoming more challenging. The reach of global corporations is only becoming more in scope. So as cautioned by Adolf Berle a generation ago, we now know that Coca-Cola is in more countries than are member states of the United Nations. A tremendous influence and reach, and how that influence is going to be exercised, I think, is really still up for debate. There is evidence of a desire for change, a taste for structuring corporate entities in a way that allows for us to count for broader social goods. B corporations or benefit corporations are getting a lot of attention these days. There is apparently talk that Unilever is considering restructuring itself in this way, but this would allow management to go beyond the myopia of looking just at profits and then considering what their impacts would be and how they might put human rights at risk. So business law, something we as lawyers have a role in shaping, could evolve. International law is another contributor to the global governance gap, in large part because international law is the law of nations. International law does not regulate in a binding way the kinds of corporations that are impacting us globally on a daily basis. So it is states that are completely sovereign. If the dominant paradigm in corporate law is the shareholder supreme, the dominant paradigm in international law is the state is supreme. State sovereigns make international law, enter into agreements. So Facebook is not a state party to any human rights treaty that requires them to protect your privacy, in the same way that Pfizer is not a state party to any convention that requires them to respect your access to medicine. The nation states are. So those are the subjects of international law. They're the entities that get to create international law. A corporation is merely an object, yet they have the potential to impact. The dominant frame of international law was disrupted by human rights. This was the notion that you could pierce inside a state, go beyond its sovereignty, and look at what's happening to the people inside of it. The lessons learned from the concentration camps discovered after World War II told us we can't simply leave it to a state in its sovereign power to make decisions. In much the same way, global economy is dismantling further or disrupting this notion of a sovereign state that's supreme, because we have other multinational powerful actors, whether they're illegal armed groups, whether they're multinational corporations. International law is still trying to figure out what to do with these sorts of actors. Multinational corporations, in a way, are not new. There were charter corporations generations ago, but they were really in the service of the crown under which they flew a flag. So the British East India Company, we can contest later, was in theory in service of its crown, but the enterprise of empire was more closely connected to a state than arguably corporations are today, where your nationality is arguably more fluid. Certainly you're incorporated in one country, but your headquarters may be in another, your operations could be somewhere else, and if you're in the internet communications technology sector, arguably your impacts are absolutely everywhere. So, what is a lawyer to do when you believe a multinational corporation is engaged in human rights violations? Some of us have tried to adjudicate these cases. I met with Tyler in your human rights clinic earlier today, who has a long history of bringing cases against corporations in the United States. That forum is increasingly foreclosed or certainly more narrowed in light of recent precedent. Other countries like the UK are starting to look at some of these cases where communities are alleging that corporations were involved in abusing their rights. We haven't had a case, at least in a human rights context, adjudicated in a way that's favorable to the plaintiffs. At most, they've settled out of court. More frequently, they're simply dismissed out of court. So not only is there a governance gap, there's arguably a gap in how to seek access to remedy for some of these problems. So where are we now? International law has not really given us much solution. Corporate law may be contributing the problem. I'm going to suggest that not law is where lawyers now need to be looking. And that's where there's a lot of activity. there's a series of policy initiatives that have been going on over time. I'm going to talk just about the last one in the interest of time, and most recent, since it seems to be emerging as the dominant paradigm. Also connected to Harvard, Professor John Ruggie over at the Kennedy School put together a UN framework and guiding principles on human rights. He was appointed by Kofi Annan, who's a former Secretary General of the United Nations, who put forward the Global Sullivan Principles. He picked up what Llewellyn Sullivan had tried to do in South Africa, brought it global, and then wanted it institutionalized and called on Professor Ruggie to come up with a framework for doing that. Professor Ruggie has put forward a framework that sorts through what the responsibilities are relative to countries and corporations, and he's determined that countries have the obligation to protect human rights, so China, Nigeria, Colombia should have been protecting human rights, certainly. But corporations operating in those countries have the responsibility to respect human rights. And here's where activity needs to happen, and a lot of good lawyering on what the content of that is going to mean. And also, involving lawyers, victims should have an access to remedy. So the guiding principles that he's put forth after this framework tell us or give us some guidance on the direction we should be going for this. With respect to corporations, what's most principal is a policy commitment and doing due diligence about your human rights impacts. So agreeing and committing that human rights are going to be part of your business operations, and then looking at how your business operations actually have impacts on the ground. Arguably, Shell didn't look at what the impacts would be for the Niger Delta region in a social sense. Sure, you do environmental impact assessments, but what about human rights impact assessments? So that's where the field is moving. And this is really calling upon human rights to be translated into the language of business, and the language of business to better understand the language of human rights. But it also has to move beyond rhetoric. The principles are starting to seed, and they're starting to spread, and they're finding their way into the International Finance Corporation's guidelines, which impacts access to capital if you are a multinational corporation. The OECD guidelines have basically plagiarized them, picked them up and put them into the new edition of the guidelines. These are often looked to by multinational corporations for what best practice is in the absence of hard binding law. We look to this standard. The International Bar Association will be voting on this in October to adopt as a standard resolution the content of the UN guiding principles and this framework. So I want to tell you 3 stories about conflicts that have happened in the past prior to the announcement of the framework and principles, and maybe engage the thought experiment of whether they would have made a difference and the role that lawyers could have played if we had taken seriously policy commitment, doing due diligence in advance, and having some kind of avenue for access to remedy. So Xintao was not the only person in prison for speaking out against the Chinese government or using internet communications technology for doing so. However, his case did get the most attention, and it did garner a coalition of corporations that came together to create a multi-stakeholder initiative called the Global Network Initiative. What this group has done is set forward a code of conduct, a policy commitment, not to violate necessarily the laws of different countries, but to engage in greater transparency and tell you what is likely to happen to your information and tell you the kinds of information requests they're getting from governments, not just the Chinese government. We now know it's the US government, and according to Reporters Without Borders, it's practically all governments. So coming together as business in a private ordered situation, they've engaged in a multi-stakeholder organization working with human rights activists to identify where their risks are, not just to their business, but the risk that they are going to have an adverse impact on human rights somewhere, and to give information about that. The second case is South Africa and the pharmaceutical sector. In 1999, a coalition of pharmaceutical companies brought suit against the South African government, arguing that the government was violating their patents. Intervening in that litigation, HIV-positive people in South Africa who were suffering without medicines argued that their right to life was being violated if we were to protect the patent rights of the pharmaceutical companies. Embarrassment ensued. The pharmaceutical companies withdrew their lawsuit, and through the Access to Medicines Initiative, a public-private partnership they started with the UN, embarked upon a program of differential pricing of medicines. Access to medicine has actually increased in regions that were underserved previously, again, a result of a community conflict and social pressure. And then finally, the voluntary principles on security emerged after several extractive companies throughout Latin America, Africa, the Asia region, all became embroiled much in the same story as Shell, having to have military security, policing by a state, and injury to local communities. They've committed to this code of conduct that they will trace throughout their supply chains and commit to greater transparency around security and mediation. So rather than shouting and shooting at protesters first, your first step is actually going to sit down and have a stakeholder engaged conversation. I've actually talked with activists in Nigeria who like this. This is a bit of a tangent, generally tend to be biased towards hard law and having rights protection. What they've said is that businesses actually sit down and talk to them in a way that their government never would. And this is largely because they have taken it upon themselves to commit through voluntary principles to do these things. So what's common across these three stories, though they're happening in different industries, different parts of the world, is that it took courageous communication and lawyering to bring different stakeholders together to come to resolution on what best practices and codes should look like and how to implement them. And this is where I want to turn finally to change. The context is changing. While there are gaps in law, the governance gap remains. It's being closed increasingly by these codes, increasingly by multi-stakeholder arrangements, but increasingly in response to demands. Demands on the part of consumers and investors for greater transparency, wanting to know what's likely to be a material impact that puts at risk their investment or that puts them in complicity with consuming goods, products, or services that are produced in ways that are unconscionable to them. So as information is garnered or shared either through exposure or increasingly mandatory disclosure regimes, companies are going to need to change their behavior and they'll need guidance in how best to do that. So I would submit that these soft standards are increasingly becoming strong through a process of greater information and greater communication. And as lawyers, that is one of our functions, to communicate. So as our profession is increasingly serving global clients or clients that have impacts overseas, this is an opportunity for us to really reassess where it is we are as a profession when we're operating in this context of standards and rules over law, and where forums may not be the conventional kinds of courtrooms that we are used to. So, in absentia, I'm going to credit Professor Wilkins, who's written, perhaps you guys have all read this or are now familiar with his report. I understand the conference is later this week. But this is a really important and I think interesting document that looks for what the profession should be looking towards in the future. And we have a conventional sense of ourselves as advisors and as advocates, but he also invites us to think about ourselves as leaders and what's going to be required of us to lead as we move into this next century and as our clients face increasingly complex challenges. So we have obligations, professional obligations as lawyers to our clients, but broader obligations as well to our profession and to society. And I think this can begin to open a conversation with clients, be they businesses, NGOs, or governments, about how best to proceed. The International Bar Association is taking a lead on this, on business and human rights, bringing us into the conversation. And the guidance that they have provided also speaks to this interesting space that we are in. So they say the guiding principles do not and cannot impose legal obligations on companies directly, but neither are they voluntary. So we've got clients now being voluntold that this is how we need to think about operating. So how do we think about that? Again, back to communication and transparency. Our general, as a litigator, relationship to information is through disclosure, through discovery, through finding facts that shape a particular narrative. We are entering an age of hyper-transparency where shaping facts and controlling narratives is increasingly difficult. So understanding that through processes of due diligence, actually gathering different kinds of facts, not just financial information and indicators, but social ones, will increasingly become something that is part and parcel of our work. The guiding principles have demands for due diligence. The guiding principles have demands for transparency, as do the ABA model rules. So our professional obligations require us to do due diligence into the interests and positions of a client to be able to be a wise counselor and advise them in an informed and full way. We also are obligated to communicate with our clients clearly. We have obligations to entities that are not our clients, which could be third parties that are impacted by corporate activity. We play multiple roles, so I'm going to, in conclusion, talk about our roles, our responsibilities, and I really want to talk at the end mostly about our relationship to risk, ultimately. But as government lawyers, if we were going to impact the global governance gap and improve the human rights conditions for people who are living in conflict situations, living in contexts where communities are violated, government lawyers have an important role in passing or implementing and drafting regulation. So as just simple technical skills, crafting rules with input from stakeholders. Corporate lawyers have a really important role in this through just drafting contracts, ensuring that norms and standards are regulated down supply chains. And then finally, NGO lawyers have a role in advocacy, in educating clients about their rights and getting them access to some kind of remedy. And this may not mean court. There's an interesting organization, Accountability Council, that's looking at alternative forums. They're looking at the national contact points at the OECD level. They're looking at the World Bank dispute settlement forums. And they're looking to educate communities in negotiation and mediation. So in the event you are able to sit down and communicate with the various stakeholders that may be impacting you, or if you as counsel have the power to influence people with influence, this is a set of skills that are complementary to what we currently call our core, and it's interesting work that civil society lawyers are doing. In many ways, lawyers are using the same tools we've always had, whether that's contract drafting, mediation, or negotiation, to find ways to enforce and protect human rights outside of court. Steve Hintoff is general counsel for the Fair Food Project. What he does is organize farm laborers in Florida, and he's gotten major multinational corporations to sign on to pay simply a penny more per pound. He has eradicated sexual violence in the fields in Florida that are part of his program. He has improved the condition of labor. He's done so through educating labor about their rights. And rather than having auditors, the labor audits itself. So they are the eyes and ears looking out for rights violations. They can report confidentially without repercussion. So this is a system of consumer demand, market enforcement, and labor monitoring that appears on this scale to be working. So they're innovative, creative things that lawyers are doing that relate to a reconceptualization of risk. So our relationship to risk is teaching students how to issue spot, or you spend time issue spotting, and that's ultimately so that you can avoid some kind of impact occurring that's adverse. I would submit that we need to rethink our relationship to risk. In the business school, risk is rewarded. You take a risk and you seek a profit, and that's a wonderful thing. We counsel avoid risk, look for caution, but we could take some risks or encourage clients to take more courageous risks in their communication, whether that's simply revealing that they have a human rights challenge through human rights impact assessments, or trying to understand the situation or perspective of another stakeholder. Sometimes that can actually avoid conflicts and mitigate risks. So relationship has been something that has helped to alleviate some of the more conflictual situations between corporations and communities. The paper that Professor Wilkins has published or is introducing also calls for looking not just at what is and being critical, but instead being constructive and creative, and then assessing risk, certainly, but not necessarily being as risk averse as perhaps our profession often counsels and cautions. Particularly when we're in a space that's not law. It's terrain that is not as stable or familiar to us, but it's shaping and it's becoming more solid. So in terms of the responsibility to respect, whatever that's going to mean, we have a role in shaping the content of that. If nothing else, lawyers are wordsmiths, and words can be given meaning. So it's important to be a part of that conversation. Much of our dominant paradigm of international law, corporate law, assumes freedom. So Milton Friedman assumed a free market when he said we play within the rules of the game. I like to think about, I'm going to end with words from another lawyer and a favorite of mine, that reformulates freedom and looks at it differently. So President Nelson Mandela spoke of freedom not just as free markets, but as an obligation to live in a way that respects and enhances the choices and chances of others. So if nothing else, as we have a hyper-transparent global marketplace, we have choices that we can exercise, not just as consumers, but also as lawyers. So as we evolve from looking at just what's law in the books or courtrooms as places where we take our conflicts, I would invite us to engage a conversation of how we can talk about standards and principles and norms and the relationship of that to our profession. Arguably, the ABA rules are consistent with this, and as we shift over time, Professor Ruggie talks about a smart mix of tools. We'll need something from this, something from that. But what we need from ourselves as a profession is to interrogate the kinds of advice that we're giving and who we look to as our clients and interests. So with that, I will open for questions. I know people have to go. Thank you.
Questions for Professor George?
Yes.
Thank you for a very interesting lecture. I'm doing a PhD on business and human rights on transnational human rights litigation against corporations.
Mm-hmm.
And you mentioned the issue with extraterritorial application of domestic law, such as the Alien Tort Statute. Mm-hmm. And also in Europe, there is ordinary tort claims. Yes. Before European courts to apply domestic law to human rights violations abroad. Right. I'm just wondering, what is your opinion of these claims? You know, applying extraterritorial law as opposed to advocating for international binding human rights law. Corporations. Okay. I mean, because there is
there's the treaty talk.
Deficit or
right.
Legitimacy deficit in having one court in one country deciding what is the international standard, to apply to a foreign corporation for a violation committed abroad. Right.
Right. So there has been a series of litigation. I'll just explain for the whole room. The United States is taking fewer of these cases. Since you're following this, the Coibel case now says that in order for a multinational corporation or something in order for Owen Sarawiwa to bring his case against the Royal Dutch Shell for events that happened in Nigeria, we're not going to hear that in the United States anymore. You have to have some touch and concern to the United States and be a U.S. company, frankly. So we are limiting that, and that may be a good thing in some ways. I mean, there have been a lot of counter arguments against the U.S. litigation, saying that it was really plaintiff's diplomacy, and it was one set of courts or one country deciding what the standards and norms would be. There is a proliferation of this litigation, I understand, in Canada and the UK and in the Netherlands that are using just common theories of tort to address these issues. I think it would be important for more jurisdictions to have the capacity to hear these cases and jurisdictions that are closely connected to where the violations occur. But sometimes those forums aren't accessible or available to victims. So that's one of my anxieties. I do not think the democratic deficit can be solved by necessarily these hodgepodge places for remedying things. I'm also not convinced, though, that a binding treaty agreement is going to do very much. I'm a human rights lawyer, I love human rights law, but there's an enforceability problem or issue. That's why I'm more interested at this time in what can be done to identify and avoid abuses, violations, adverse impacts. The remedy piece of this is sorely underdeveloped, and there needs to be more. I've got a colleague in the room who I know is going to be leaving soon who's working on this at a state level, and some of my students are as well. So looking at not just federal courts, but state courts, looking at other forums where you can bring these kinds of claims and also have remedy. I'm very interested in the national contact points of the OECD and other places where you can get some adjudicatory finding that a violation has occurred. So the accountability piece of this, I think, needs to happen on multiple levels in different places, but it'll be context specific and it'll depend on the particular conflict. And in some places, courts may not even be the best option, because if I win after 20 years, that's not really a win. As I talk to, Steve Hentoff was the lawyer for the Fair Food Project. He's said this over and over. If he goes to court, he's likely to lose. None of these cases have been successful, or very few, when brought by people who've had their rights violated. What's better for him is to sit down, to settle, to have some kind of accord or agreement to avoid future harm. But I do take your point, and I don't know that this has answered it fully for you, but it's very much still under development. I don't believe that ATS is dead in the United States.
No, there's just a disagreement, the circuits.
Yeah.
Whether it should apply as territory.
Right. Short answer is I think it should. Yeah. Yeah.
Just to follow up on that a little bit. So are you saying that some of these options that you've sketched out are not only the only options to solving some of these problems, given the governance gap and all that, but they're also better options?
I think these are the better options. I think the best option, the better option, is to educate corporations, to have accountability be beyond courtroom, to have it be public, to have issues and matters disclosed. I think that market enforcement is going to get us further faster than a civil lawsuit in any forum in any country. That's my sentiment. Just kind of based on the lack of progress I've seen, the few victories that litigation has to show for itself, I think there needs to be more creative thinking about what remedy looks like, but ultimately the harm has to stop, and that requires a new way of doing business.
So then my question becomes, so how do lawyers go about figuring out what the normative basis for their advice to corporation is? I mean, because, for example, in this case that you mentioned involved in South Africa and medicines. Yeah. And imagining that this corporation has a U.S. trained lawyer as one of its main advisors, I don't see that it's against U.S. law, to protect patents.
No, it's not.
Right? Quite the opposite. So, I mean, how is this person going to understand that by having this company operating in other jurisdiction, this company may be successful to claims that approach the core of its business differently. So that's one of the questions. And the other is, don't you think that in order for corporations to progress towards this way you're claiming that that's the best one, there should be a shift in the dominant paradigm, legal paradigm too? And I say that because, especially in the U.S. Anglo-American legal culture, when we talk about the law, it's very much about observing legal duties, and when that doesn't happen, being subject to liability and adjudicatory mechanisms. So if one company decides to disclose that has some problems related to human rights.
Yeah.
How come couldn't that turn against the company in terms of people starting to file lawsuits against it?
Right. Both good points. I thought you were going to go somewhere else with the second. Okay, so your first point is that
Legal
the
pluralism,
U.S.
basically.
Well, so what is going to guide a lawyer's advice if we are in a context of non-law? What's going to ground the normative foundation?
Or multiple legal orders, actually.
Multiple legal orders. Well, in the business and human rights context, right now I argue that it's the guiding principles, because that was a relatively consensus document, or even if you think it's not, it's got the endorsement of the Human Rights Council, and increasingly it's starting to seed and spread and take hold. What I like about it is it incorporates by reference international human rights legal standards. So it's not far from law, it's taking law and trying to translate it into terms that business can understand. So that's the translation piece of this. So I'm not saying we throw all caution to the wind. This does have to be anchored in normative frameworks that are created through processes. So we have the frameworks, and then we have for us our model rules of professional conduct to guide us with respect to what our obligations are to our client. I think what I'm trying to say is that we need to think about our clients, particularly organizational clients, not just as the board of directors, but as a set of relationships, as stakeholders. So if we are advising the pharmaceutical sector companies that are operating in South Africa, certainly they have patents, but appreciate that you're entering into a context where the goods and services that you provide and produce are in great demand, and this is a compromised context. So it could be you need to operate differently in these regions. So an appreciation of not just a universal principle that patents are supreme or human rights or this or that, but understanding and appreciating what domestic dynamics are in a particular operating context is important. That's usually something that's far afield of what we think, teach, and train here, but that goes back to relationships, working with lawyers in other countries, working with lawyers across the negotiating table. I think we can teach and train ourselves a lot and our clients as well. So that's the first part of your question. The second part of your question is about transparency, and if I share something, I'm the Gap, and I say I found 2 kids in my factory and somewhere, and H&M hasn't said that, does that put me at a competitive disadvantage? I think one of the places where I'd like to see more standardized disclosure kinds of requirements is precisely in the space of transparency. There are people across the river at the business school who work on integrated reporting, who argue that not just financial reporting, but social reporting should become something that's foundational. This is early and nascent yet, but the more information is shared, I think conditions can improve. So the multi-stakeholder initiatives that I gave as an example, what you see in all of those that I think is absolutely fascinating is previous competitors, companies that compete, coming together to collaborate around what are going to be the social norms and standards for our industry. It's an industry trade association in a way, but looking at things that are broader. So I think that can sort of begin to piece towards what is a standard set of information we want to share. Businesses were in complaint about this too. I've sat in on meetings where they say they have more activist shareholders, so this group wants to know this information, another group wants to know that information. The way they're dealing with it now is simply publishing everything in a sustainability report that really is responsive to the kinds of questions that they're getting. Seems to differ by industry, and right now it's ad hoc and simply reactive. As lawyers, we could think about how to guide people in being more proactive. What is relevant information? What is material information? What's information that's likely to be transformative and put you in a better position where you're not putting others at risk?
Isn't there, I'm going to play devil's advocate for a minute, isn't there a simplistic, direct way to get at this?
Yeah.
And haven't we seen it play out in the sovereignty of states within the United States? I mean, most recently with the state of Indiana. I mean, if we're going to ask corporations to behave better, we started with the premise the only thing they understand is profits. They responded to Indiana quickly and effectively. And even in Arkansas, it weren't probably for a phone call from Walmart,
Yeah.
Arkansas would have gone a different way.
All right.
We see with the Anti-Bribery and Corruption Act,
Mm-hmm.
changed behavior with multinationals, because there's a price to pay.
Yeah.
If they're colluding with foreign countries and actors in those countries to behave poorly.
What's the price?
There's a fine, and people could go to jail.
Oh, for the Foreign Corrupt Practices
That's right.
Act, yes, but for Arkansas, for Indiana,
Well, they could lose companies, they could lose headquarters, they could lose employees, they could
the
lose
states,
revenue. The states.
because the businesses are going to take powerful action on the social issue.
Are we not at a unique point, particularly with Citizens United, where we've defined corporations as people, to really put a moral tax on them? Say, if you're going to engage, if you're going to be in the line of the chain of discrimination,
Yeah.
whether it be race, gender, sexual orientation, you're going to be prosecuted. If you're, I'm throwing it out there,
Uh-huh.
if that's the only thing they understand.
But Walmart wouldn't have been prosecuted for keeping headquarters in Arkansas if
No.
Arkansas was a discriminatory state. What they said to the state of Arkansas is, we're not going to put up with it.
Right.
And what made them say that? Us, or what they perceive to be us, right? Like social pressure, social norms that are shifting and changing to become more inclusive. And they couldn't afford, I imagine, to be part of something continued to be exclusionary in such a blatant way.
Right.
So that's the taste for transparency, that's the taste for choices and changes, and they are responsive to that if it's a powerful norm. There are other norms that are important but aren't as powerful. Okay, child labor is a pretty powerful one, but privacy might not be one. When I talk to people in the ICT sector, they say that, you guys, we don't understand our privacy or the amount of privacy or information that we're giving up. So some of this still does require business and legal leadership. But I do take your point. I mean, I do think, but those aren't drivers that are law.
No.
That's not law. I would put that in the space of not law. It's a reaction to not having discriminatory laws, but nothing required Walmart to take the action that it did. The other thing that I've been watching, and this is a bit of a tangent, is Race Together. Anyone following this?
Yeah.
Howard Schultz just took a lot of heat for that. He's a very unconventional CEO. He's taken positions on all kinds of social issues, and that is just against the primary paradigm in every way possible. Yet, he hasn't really been hit or hurt for it. Right? Starbucks is still doing fine. I mean, backtrack a bit, but tried to take a dialogue, and what was that? That was taking a risk. So some of this, even though it's about protecting rights and caution, that was taking a risk. Yeah.
And I get that you're at law school now,
Yeah.
but why couldn't you give a similar talk at, why is it the lawyer specifically? Why not, the Walmart example, it was because they were going to lose business.
Yeah.
This is what makes that norm so powerful, I
Yeah.
think.
Mhm.
And why isn't a chief marketing officer or something like that that plays the central role? Why is it the lawyer specifically?
Because lawyers give meaning. We're the ones working with words. Those reports don't go out without legal review often. But I think this talk could be given at the business school, and I'd like to be talking to more business students. But more often than not, courses like the ones I teach on corporate citizenship, those are taught in law schools. And I think that it's because we have a role in shaping the architecture of what these institutions are, what corporate law allows a business to do. Understanding how far the business judgment rule extends. So there are ways law is still related, but the thesis of the book I'm working on and what I'm working around is getting lawyers to think beyond law, because ultimately we need a broader ethic than law to change any of this. And this broader ethic than law becomes binding through market forces. So I guess our role is
I guess
messaging.
what I'm wondering is, for the Walmart example, who
Yeah.
walked into the CEO's office and said, if you don't come out against this law in Arkansas, we're going to have a public relations nightmare on us. And
Yeah,
a
probably the
business
public
nightmare. Was it the
relations
GC? Was
Yeah.
it the? I mean, I think there's an interesting
Yeah.
question there.
Yeah, and at least when I talk to marketing people, they don't generally like to talk to lawyers. You probably know this. A friend here is more business community and knows that. But I do think we need to be part of these conversations more. And the reason we're not brought into the room is everybody I talk to says all the lawyers just always say no all the time. And we might want to let yes live in the room a little bit longer. And some of that will require us suspending our immediate, these are all the ways in which this could go wrong. So, yes.
So this kind of falls into one question I had, which is, and I'm not sure I'm right about this, I'm probably wrong, but about the use of the term human rights and human rights movement and all this, because it strikes me it does at least two things. One is it gives lawyers a hook, right? Because there's this sense rights of these things out there, you know, they're solid things, there are legal claims that are made.
Yeah.
Even though many of the things you just talked about were not about that at all, right? So it kind of, and not only that, it empowers certain types of lawyers, right? Because there was a human rights movement before business and human rights movement, right? And so there was a group of people who were interested in these kinds of things, and so then when these issues start coming up, oh, it's these kinds of lawyers who do these kinds of things, and I worry. And I also think there's a lot of strengths of you trying to appropriate the language of human rights, which people around the world understand, that sort of thing. But as claims generally against a state, but many of the things you talked about were tort law, contract law, processes, regulation, corporate governance. And you know, the three examples you used were like people dying, but that, I get the sense that's...
Those were all human rights violations of different generations.
No, those were
different
human rights. But a lot of the things we're trying to get at are kind of softer things in between, in the sense of we want, you know, as you were saying, we want lawyers to be kind of good stewards, you know, advising in a general way for the social good, which doesn't always ramp up right against what would be labeled a clear rights violation. Right. So we're actually, most companies are much more concerned about this gray zone in between than we're about to kill somebody in Nigeria. Well, hopefully that's not where most companies are. And so does this kind of use of the term human rights kind of distract our attention into the wrong, and it empowers certain groups of lawyers and empowers, you know, in a certain way in these ways, but is it kind of distracting us from what you just said we need to do?
I have an intellectual commitment to continuing to use the rhetoric of human rights, but I appreciate, for the reasons you've articulated, why it could be problematic. I'm not persuaded that it's giving particular types of lawyers, human rights lawyers, all kinds of power necessarily. What I'm hoping it's doing is educating. The resistance to it is businesses would prefer to talk about this in terms of ethics. That's generally how they talk about it, or sustainability. But I think that doesn't capture fully what's at stake and what's going on. And if we can appreciate it and approach it from a human rights context, that also gives more opportunity to do things differently. So in the human rights context, for example, we're deeply concerned in procedure about having legitimacy, transparency, and due process norms inform what we're doing. That's a conversation that'd be interesting to have with people who do business strategy, but it's not my understanding that that's necessarily the same kind of approach. So I still am committed to the belief that there's something here to be gained by engaging this on these terms that I'm still working through. So I do take the challenge, and I get it quite a lot. Because we talked social responsibility for decades, right? We've talked sustainability for decades. There is something different that human rights does, and that humanizes the impacts that you have on others. It humanizes the choices that you can choose to make or not. But it sets the stakes differently. And maybe that's too much of a move, but I think we need to move there because lots happening that's bad. So.
One more question? Anyone? Well, Professor George will be around for a few more minutes, but thank you so much for a wonderful presentation today.
Thank you very much.